to PCQ 6 have not been able to rebut the presumption of regularity, which inures to the first respondent under the law, which can only be rebutted with cogent and credible evidence, CAPC and Sheriff and others. From the totality of the evidence adduced on this issue, I am of the considered view that petitioners have failed to prove substantial non-compliance with the provisions of the Electoral Act 2022. Issue 2 is therefore resolved against the petitioners and in favor of the respondent. The issue 3 is whether from the totality of the evidence, the petitioners have proved that the presidential election held on 25th February was invalid by reason of corrupt practices. Well, here again we have considered the submissions of counsel. So in their petition, the petitioner made allegations of suppression of scores, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation and manipulation of results where no election took place, overvoting and wrong computation of results. These allegations are contained in paragraph 60 to 78 of the petition. In paragraph 60, 61, 62, 64, 65, 68, and 69 of the petition, the petitioners allege that due to the first respondent's refusal and neglect to upload and transmit the result of the election to the IRF on the day of the election, the first respondent suppressed the actual scores obtained by the petitioners. According to them, the suppression of the first respondent scores, which occurred in 2088 polling units, was orchestrated by the first respondent, deliberately uploading readable and blurred forms EC8S on the IRF, and thereby suppressed the lawful scores obtained by the petitioners in the said polling units. They further alleged that in Rivers State, during the collation exercise, the first respondent announced scores of the petitioners as 175,071 votes, and the second and third respondents as having 231,591 votes, when in actual fact, the petitioners' lawful votes are 205,110, while that of the second and third respondents ought to be 84,108. They similarly allege that in Benue State, the first respondent suppressed the lawful votes obtained by the petitioners when it announced their votes as 308,372, and that of the second and fourth respondents as 310,468, when the actual votes of the petitioners were 329,000, and that of the second and third respondents at 300,421. The petitioners also alleged that the first respondent was purporting to upload the result of the presidential election on the IRF, embarked on massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, as well as uploading correct results. They stated that if the results of polling units, wards, local government states are properly tabulated and calculated as required by the Electoral Act and the regulation and guidelines for the election, the overall results of the election and the percentages scored by the political parties will show that the petitioners won the presidential election of 25th February 2023. They stated that the petitioners should rely on a report of inspection of the electoral materials. In the earlier ruling of this court on the preliminary objections raised by the respondents on the propriety of the averments contained in the petition, we held that apart from the allegations of inflation and reduction of votes in Rivers and Benue states, where the petitioners have stated the figures alleged to be inflated and reduced, the other allegations of the petitioners were nebulous and bereft of the material particulars. We held that the said averments contain no particulars of the polling units where the alleged infractions took place or the figures alleged to have been inflated or reduced. We had struck out those paragraphs for offending paragraph 4(1)(d) and 2 of the first schedule to the Electoral Act 2022. Indeed, apart from the strict requirement of stating material particulars in election petitions, it is also tried that in civil litigations, including election petitions, whenever fraud or any other crime is alleged, material facts of such allegation of fraud or other crime must be pleaded and clearly set out. The Omoborio and others was adjusting, Deso Limited and Honey Legion, Lorin and others versus Tangolana and others. The petition allegations of suppression of votes, inflation and reduction of votes, massive misrepresentation and manipulation by uploading fictitious results all amount to falsification of results of an election. This is Sadija versus Sukur. The Supreme Court held that allegations of inflation with non-existing votes is another way of alleging falsification of results. Indeed, in Haruna and Modibo, the Supreme Court held that where a petition is based on allegation of incidents of fraudulent acts, manipulation of results, or falsification of results, that allegation is criminal in nature, and evidence required in proof thereof must be clear and unambiguous. In other words, the proof must be beyond reasonable doubt. This section 135 sub 1 of the evidence Act and cases of Buhari and Obasanjo, Emmanuel Umana, Ipiazu, Oti, Abubakar, and others for Yaradua, Omishore, Ariboshola, Magaji, and All Progressive Congress. In order to establish falsification of election results, the petitioner must produce in evidence two sets of results, one genuine and the other false. In the cases of Kaki and PDP, Mwobodo and Ono, Adewale and Olaifa. See also Chima Anoze versus Dr. Ken Obichere and others. And Joseph Olujimi Kolawole Abaje versus Babatunde Raji Fashola. And Okechuku and another versus Onyebu. To prove their petition, the petitioner also, who indicated during pre-hearing, they will call 50 witnesses, called only 13 witnesses. They are mentioned here. Of the above 13 witnesses, only 3 had their witness statements on oath filed along with the petition. These are PW1, PW2, and PW12. In our ruling on the respondent's objection to the competence of the petition witnesses at the beginning of this judgment, we had struck out the evidence of PW3, 4, 5, 6, 7, 8, 9, 10, 11, and 13 on the ground that their witness statements on oath were not filed along with the petition as mandatorily required by paragraph 4(5)(b) of the first schedule to the Electoral Act. However, even if the statements of those witnesses of the petition were to be considered, the question is, are those testimonies cogent and credible to establish the petitioner's allegations stated above? By Annie. He said, from his knowledge of software engineering and computer operations, RF is a server and is accessible to the public. He said he was aware that the information or data generated or inputted in the beavers were operating online or offline, were transmitted to the annex servers, including virtual servers hosted on AWS Cloud. On cross-examination of the first respondent, however, the witness admitted that his opinion was based purely on his reading of the Electoral Act and ANEC guidelines, and that he was not familiar with the applications and operations of the beavers machine. He stated that he did not play any role in the elections. Indeed, as admitted by the witness, his statement, particularly paragraph 10 to 13, is a virtual reproduction of Section 38 of the Electoral Act 2022. On cross-examination by the fourth respondent, he admitted that he did not state his educational or professional qualification or experience in his statement on oath. He also stated that his investigation was based on publicly available application program interface, API, and collected information through it like Form EC8S. He said he did not have the documents and forms he used and that everything was in his laptop. Contrary to the speculation of the petitioners that INEC was not prepared to conduct the promised credible, authentic, and transparent election, or that it deliberately or mischievously allowed a compromised IT infrastructure to be deployed for the conduct of the presidential election, PW2 confirmed that Amazon Web Services is the most secure service providers in the world, and that it is used by corporations, companies, individuals, and governments that are most concerned with security. In his entire evidence, PW2 did not talk about the contents of any result. Instead of supporting the petitioner's allegations, the evidence of this witness supports the case of the first respondent. As for PW3, PW5, and PW6, they merely tendered flash drives containing speeches of the INEC chairman, Mahmoud Yakubu, and INEC National Commissioner, Festus Okoye, wherein they gave assurances that results of the election will be transmitted to the IRF for public viewing. Being mere assurances, the evidence of these witnesses had no utilitarian value in establishing allegations of corrupt practices made by the petitioners in this case. In his evidence, PW4 tendered exhibits PZD 1, 2, and 3, which he claimed to be the report of his analysis of the presidential election. The witness also tendered 4 boxes containing what he called 18,088 blood polling unit results downloaded from the IRF portal, which were also admitted as exhibits PCE1 to PCE4. However, in the earlier ruling of this court on the respondent objection, we have struck out exhibits PCD 1, 2, and 3, as well as exhibits PCE 1 to 4, along with the witness statement on oath of PW4, which was not filed along with the petition since the documents were tendered through the incompetent witness. The witness claimed in his evidence that from his investigations, the scores on Forms EC8S of 39,556 polling units were inaccessible as they contained uploads not connected with presidential election, and that the number of accredited voters affected by the 18,088 blood result was 2,565,269, while the number of voters who collected their PVCs was 9,165,191. According to him, this signified that the votes of 5,533,553 accredited voters were discountenanced by the first respondent. He added that 23,119,298 registered voters collected their PVCs in those 39,546 polling units, and concluded that both the number of accredited voters of 5,553,553 and number of voters who collected their PVCs of 23 million plus polling units far exceeded the margin of lead from the first respondents' announced result of 1,807,206 over the first runner-up and 2,693,193 over the second runner-up. PW4 also stated that in Benue State, neither the results he obtained from the IRF nor the CTCs of Forms EC8S matched the results of the first respondent. He stated that the annex CTCs of Forms EC8S showed that LP got 272,468 votes and APC got 256,852 votes, while the results from the IRF portal showed that LP got 260,796 votes, while APC got 268,630 votes. He added that the INEC announced result showed that LP got 308,372 votes and APC got 310,468 votes. He concluded that by adding uncovered votes and deducting votes affected by overvoting, manipulation, alteration in Benue State, LP got 281,426 votes, while APC got 258,683 votes. A look at the 18,088 blood polling units results, which the witness claimed to have downloaded from the RF portal, show that they were not certified by the first respondent. Being secondary evidence of public documents, they are clearly inadmissible. See Section 89E and 90C of the Evidence Act 2011, and the case of Emeka versus Ipiazu and others. Of note is that PW4 admitted under cross-examination by first respondent that the primary source of the data he used in his investigation is from the RF portal. This clearly means that he based his investigation on inauthentic data, since the essence of certification of public document is to ensure authenticity of public documents. See the cases of Ebwe and Araka and Emmanuel versus Umana. Also under cross-examination, PW4 stated that his reference to Form EC8A and the result on RF portal are not the same thing, and that Form EC8A is a paper, while the result on RF is a copy of it. He particularly admitted that by his reference to blood Form EC8As on the RF, he was not suggesting that the hard copies of Form EC8As are also blood. This admission by PW4 also dealt a death knell to the allegation made by the petitioners in paragraph 60 of the petition that the first respondent suppressed the first respondent's cause in 18,088 polling units by deliberately uploading unreadable and blood forms EC8As on the RF. In fact, PW4 had under cross-examination completely rubbished his own report when he admitted that the RF portal is not capable of collating and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to RF, while the hard copy of Form EC8A is and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to RF, while the hard copy of Form EC8A is taken to the collation center, which he stated is collected at the ward, local government, state, and national collation centers. He also admitted that since the result in the Form EC8A is taken to the collation centers, the failure to transmit its image in RF, or that the result already entered in Form EC8A. Again, the witness admitted under cross-examination that his report in exhibits PCD1, PC2, and PCD3 only covered the two states of Rivers and Benue, and that he worked on only available data, that if he had more data in his report, it would have been different. He further admitted that his report, exhibits PCD1, 2, and 3, is not a product of expertise, as any secondary school student can do the simple arithmetic involved in it. This admission by PW4 effectively rubbishes his entire report as inconclusive and manifestly unreliable. On the whole, the evidence of this witness, even if it were to be considered, is devoid of any probative value. As for the evidence of PW7, we had earlier analyzed and evaluated her testimony and found that she was not only a person interested in this petition. The report in Exhibit PCJ 3A to F, which she brought to the court purportedly as an expert witness, was merely downloaded by her from AWS site, which was openly accessible to the public. Her evidence is also of no probative value. With regard to the evidence of PW8, I have earlier analyzed and evaluated his evidence while resolving issue 2. Suffice it for me to state that I had found that PW8, having admitted that in the course of his commissioned work, he had read the petition and the first respondent's reply, as well as the Electoral Act and annual regulations and manual, and that he finished his final report in May 2022 during the hearing of this petition. PW8 had practically worked to a predetermined answer, and his evidence was of no probative value. PW9, who gave evidence as an accredited observer of the election, had stated that everything about the election in the polling unit, which he observed went as accreditation, and voting took place. The votes were counted and the results were announced and recorded on Form EC8A, but was not uploaded on the IRF at the polling unit. Under cross-examination by the respondents, he stated that from his observation, the election went on smoothly in his polling unit and that the election officials complied with the INEC regulations. He stated that the result was taken to the collation center by the election officials. Rather than support the petitioner's case, the evidence of this witness actually reinforced the response case that the election was conducted in substantial compliance with the Electoral Act and INEC regulations and guidelines. PW10 stated that he acted as an ad hoc supervisory presiding officer for Madagali Ward and that on election day he collected the materials with security agents and other INEC ad hoc presiding officers. He stated that voting went on well until 6:30 p.m. and all voters who were on queue by 2 p.m. duly voted at Unit 004 DISA. He stated that after sorting and counting of the votes, the presiding officers did the entry and snapped the results with the beavers, but were unable to transmit and upload same to the IRF portal after the result of the National Assembly election was uploaded. He stated that when the presiding officers complained to him, he asked them to come to the registration area, where he requested them to meet the registration area center check, who asked them to submit the beavers to him for transmission, but was unable to upload. On cross-examination by the First Respondent Council, PW8 stated that apart from the small issue between agents of APC and PDP, which was satisfactorily resolved, everything went well and the results were entered in Form EC8S in the units and were properly announced. He added that the physical copies of the Form EC8S were taken to the Ward Collation Center. On cross-examination by second and third respondents, the witnesses have confirmed that notwithstanding the difficulty in uploading the results, the collation of Forms EC8A took place in the ward. The evidence of this witness also supports the case of the respondents rather than of the petitioners. PW11, head of the Legal Services National Information Technology Development Center, NIDA, merely stated that he was subpoenaed to produce and tender the following documents. A, correspondence of documents, letters, emails sent by him, sent by or from Independent National Electoral Commission to National Information Technology Development Agency requesting for the IT clearance approval of the IT infrastructure to be deployed and or deployed by INEC for the conduct of 2023 general elections. B, the certificate of clearance approval issued by NIDA to INEC pursuant to any request in A above. C, a report submitted by INEC to NIDA containing certification for the testing review of the IT infrastructure deployed for the conduct of the 2023 general election. He stated that they don't have any of the documents in their office. Under cross-examination by the second and third respondents, he stated that the NIDA Act does not contain cybersecurity standards. He also stated under cross-examination by the fourth respondent that their supervisory ministry is Ministry of Communication and Digital Economy, and that the minister stated that there were 16 million attempts to hack the INEC IT infrastructure on the day of the election. The evidence of this witness is of no assistance to the petitioners. W12, the petitioner's star witness, whose evidence was merely a copy of the averments in the petition, stated that on the day of the election, he voted at his polling unit at Dawaki, Abuja, after which he went to the situation room of his party, the second petitioner. He stated that apart from his polling unit and the situation room, he was not present physically at any other place on the day of the election. He stated that he was not a collation agent or polling agent in any polling unit or collation center. His evidence in chief was therefore mostly laced with hearsay. It is settled that hearsay evidence is inadmissible and has no probative value. Apart from his evidence in chief being inadmissible hearsay, Exhibit X1, a certified true copy of the judgment of Federal Court Abuja in suit number FHC ABGCS 1454-2022 was tendered through him under cross-examination by the first respondent, and he read out a portion of the judgment of the court which was to the effect that the first respondent was under no mandatory obligation to electronically transmit or collect results of the election. He also admitted that he did not state in his statement on oath any figure unlawfully ascribed to the second respondent and third respondent by the first respondent. He also stated that his party had agents throughout the Federation with over 133,000 votes. When asked by the second and third respondents' council to state the score of the Labour Party, the witness stated that he will not know scores of the Labour Party because the results are still being uploaded on the IREF. He added that he will not know the unlawful votes accredited because he is not an expert, and that the wasted votes are part of the statement made by the expert. When cross-examined by the fourth respondent, PW12 stated he was not aware that ANEC chairman had given a statement that ANEC will not transmit results electronically. When confronted by the fourth respondent's council, he confirmed that his statement on oath wherein he stated that he will rely on the evidence of forensic expert was made on 20th March 2023, while the final expert report he was relying on was made in May 2023. It is clear that PW12 relied on an expert report that was not in existence at the time he made his statement. It is obvious that the evidence of this witness lacks credibility and is therefore manifestly unreliable. PW13 was the only presiding officer called by the petitioners in this petition. His evidence was that in his polling unit 035 at Open Field, Ward 04, Chikun local government area in Kaduna State, the election went well, and that thereafter all efforts to upload the presidential election results as captured in Form EC8A failed except the National Assembly results. That when all efforts failed, he proceeded to the collation center with other ad hoc staff. When cross-examined by First Respondents Council, he stated that he recorded the results manually, and the only problem he had that day was the uploading of the result, and that when he could not upload the result, he called his supervising officer, who told him to take the result to the Ward Collation Center, which he did. On cross-examination by Second and Third Respondent Council, he confirmed that after recording the result manually, he signed and the party agents also signed. When cross-examined by the fourth respondent, he stated that after signing the result, he gave copies to party agents. The evidence of this witness actually supports the case of the respondents that the election was conducted in substantial compliance with the Electoral Act 2022. In Buhari and INEC and others, the Supreme Court clearly stated law as follows. Quote, a petitioner who contests the legality or lawfulness of votes cast in an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the illegality or unlawfulness of the votes cast and prove that the illegality or unlawfulness substantially affected the result of the election. The documents are amongst those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of the election, not those who picked the evidence from an eyewitness. No, they must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of the votes cast and the subsequent result of the election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only the documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities both in the conduct of the election and the recording of the votes. Wrongdoings and irregularities which affected substantial result of the election. Proving an election petition or proof an election petition is not as easy as the Englishman finding coffee on his breakfast table and sipping it with pleasure, particularly in the light of Section 146(1) of the Electoral Act. A petitioner has a difficult, though not impossible task, close of court. See Mohammed and another for Anladi and others. In this petition, where the petitioners have labeled several allegations against the first respondent, such as suppression of votes, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation, manipulation of results, where no election took place and wrong computation of results, it is evident from the above that the petitioners have not laid any credible evidence to substantiate those allegations. Of the 13 witnesses recalled, only 2 are presiding officers who were present at the polling, who were present at their polling units. Hence, the petitioners have not been able to establish any of those malpractices which they allege. The evidence of the witnesses which the petitioners call as experts to try to establish that the first respondent is mandatorily required to transmit election results for the purpose of collation or to link the delay in the upload of the presidential election results to average by the first respondent to any of the malpractices which they allege are devoid of any value. The petition allegations have remained mere speculations and unfounded accusations. The petitioners have failed to establish beyond reasonable doubt the corrupt practices which they allege as required of them under Section 135(1) of the Evidence Act 2011. On the petitioner's allegation of overvoting, Learned Counsel for the first respondent contended that to prove overvoting, the direct record of accredited voters in the beavers machines are required alongside the voters register of the affected polling units. He pointed out that the petitioners failed to produce the beavers machines and the voters register. He submitted that the petitioners want this court to rely only on the expert opinion of PW4, which is not credible. He submitted that when PW4 was confronted with the results in polling unit 002 of Ward 7 of Degema, LGA, River State, which was part of his report on overvoting, in Exhibit PCD2, he stated that there was no overvoting, as the number of votes cast was 40, while the number of accredited voters was also 40. He relied on Oetella and INEC and urged this court to discountenance PW4's evidence on overvoting. The petitioner's allegation of overvoting is contained in paragraph 72, 76, and 77 of petition, which have been produced here. In the area ruling of this court, the respondents' various preliminary objections to the competence of the above affirmative petitioners' allegation of overvoting were upheld, and the court had struck out the said paragraphs for being vague, nebulous, and imprecise, having failed to disclose the specific polling units in the state where the overvoting is alleged to have occurred, the number of votes affected, the alleged margin of lead, etc. Indeed, in that ruling, we had observed that the forensic report containing the details of the polling units and other information which the petition said they have incorporated to the pleading by reference were not filed along with the petition as to be part of the pleadings. In proof of their above allegation of voting, however, the petitioners solely relied on the evidence of PW4, the subpoenaed expert witness, as well as the forensic report made by him, which is contained in Exhibit PCD 1, 2, and 3. PW4's evidence was basically that from his investigation in Exhibit PCD 1, 2, and 3, he discovered that there was overvoting in 4,477 polling units, which affected 2,317,129 voters who had collected their PVCs. He stated that this also exceeds the margin of lead of 1,807,206 over the first runner-up. He also stated that from his analysis of River State results, the first respondent announced results which were inconsistent with those uploaded on the IRF portal. PW4 also stated that from the Forms EC8As downloaded from the IRF portal, there is evidence of manipulations and alterations in favor of APC and against the Labour Party LP. He stated that from the results on the IRF portal, LP got 208,564 votes, while EPC got 118,999 votes in River State. as against 175,071 votes for LP and 231,591 votes for APC. He concluded that when the unlawful votes are deducted, it will amount to 205,110 votes for LP and 84,108 votes for APC. In the ruling on objections to witnesses and documents made in the earlier part of this judgment, the witnesses stated on oath, a witness statement on oath of PW4 was one of those struck out for offending paragraph 45B of the first schedule to electoral 2022, them not having been filed along with the petition. With the statement of PW4 struck out for being incompetent, exhibits PCD 1, 2, and 3, the forensic report tendered by him, were also struck out for being inadmissible. As stated earlier, the oral evidence of PW4 contained in his witness statement on oath and his report in exhibit PCD 1, 2, and 3 are the only evidence adduced by the petitioners to establish their allegation of overvoting. With the witness statement on oath of PW4 having been struck out for being incompetent, and the forensic report in exhibits PCD 2, 1, 2, and 3 also struck out for being inadmissible, there was no other evidence to substantiate the petitioner's allegation of overvoting. The petitioners have therefore failed to prove their allegation of overvoting. Issue 3 is also resolved against the petitioners. So based on the establish the allegations of corrupt practices and overvoting. In consequence, issue 3 is also resolved against the petitioners and in favor of the respondents. Issue 4 is whether from the evidence adduced by the petitioners, the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. This issue deals with Section 134, subsection 2 of the Constitution on the issue of 25% of votes in Abuja. So whatever it is, we will read it. Why did I read? Well, the resolution of this issue basically borders on the interpretation of Section 134, subsection 2B of the 1999 Constitution. The appropriate starting point for the resolution of this issue, therefore, is to reproduce, for ease of reference, Section 134(2)A and B of the Constitution of the Federal Republic of Nigeria, 1999, as amended, the interpretation of which is in contention. It reads thus: a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than 2 candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation and the Federal Capital Territory. The contention is as to the interpretation to be accorded to paragraph B of subsection 2 of Section 134 quoted above. In particular, the contention is whether or not, by the wordings in that paragraph, a candidate must, in addition to scoring not less than 1/4 of the votes cast in at least 2/3 of the states in the Federation, also score 1/4 of the votes cast in the Federal Capital Territory, Abuja, before he can be deemed to have been duly elected. In other words, whether in determining 2/3 of the states of the Federation in the Federal Capital is to be included and regarded as one of the states of the Federation, or his status is to be regarded as distinct from the other states of the Federation, such that scoring 1/4 of votes in the FCC is a mandatory requirement for a candidate to be deemed duly elected as president. It is pertinent to state that unlike interpretation of statutes, the interpretation of the Constitution has its own guiding principle. We'll look at the principles as stated in Federal Republic of Nigeria versus Ganjua, reported in the electoral report. Hence, a broader interpretation should be preferred unless there is something in the text or in the rest of the Constitution to indicate that a narrower interpretation will best carry out the objects and purpose of the Constitution. B, all sections of the Constitution are to be construed together and not in isolation. C, where the words are clear and unambiguous, a literal interpretation will be applied. Thus, according to words, their plain and grammatical meaning. D, where there is ambiguity in any section, a holistic interpretation would be resorted to in order to arrive at the intention of its framers. E, since the draft person is not known to be extravagant with words or provisions, every section should be construed in such a manner as not to render other sections redundant or superfluous. F, if the words are ambiguous, the lawmaker's intention must be sought first in the Constitution itself, then in the other legislation and contemporary circumstances. With all due respect to counsel to the petitioners, their interpretation of Section 134, subsection 2b of the Constitution, founded principally on a fixation that the word "and" appearing between the phrases, it has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states of the Federation, and the Federal Capital Territory of Abuja is completely fallacious, if not outrightly ludicrous. Even their recourse to the case of Abubakar and Yaradua does not help their argument because the JSC made it clear that a purposive rule of interpretation will not be appropriate where the intention of the lawmaker is clear, precise, and unequivocal, so much so that a person can say, yes, this is what the lawmaker has in mind. Thus, in the interpretation of the Constitution, the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provision. The Global Excellence Communication Limited, Donald Duke, AG Bender State AG Federation, Saraki versus FRN, Sky Bank PLC, Iwu, Kelim versus Gobang. That this is the position is not at all open to doubt. In Bronic Motors Limited versus Wema Bank Limited, Nnamani JSC or blessed memory, speaking from the Apostle Court, confirmed it when, after a painstaking analysis of the cases on the point, said at pages 30 to 32, that, quote, a constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for now, but for generations yet unborn. In construing it, undue regard must not be paid to merely technical rules. Otherwise, the objects of its provisions, as well as the intention of the framers of the Constitution, will be frustrated. As stated in Minister of Home Affairs versus Fisher, a constitutional requirement should not necessarily be construed in a manner according to rules which apply to acts of Parliament. Although the manner of interpretation of constitutional instrument should give effect to the language used, recognition should also be given to the character and origins of the instrument. Such an instrument should be treated as sui generis, calling for principle of interpretation of its own, suitable to its character, without necessary acceptance of all the presumptions that are relevant to legislation or private law. It has also been accepted by all our courts that a broad and liberal interpretation should prevail in interpreting the provisions of our Constitution, although one has constantly to bear in mind the object which such provisions were intended to serve. Sir Udo Udoma, JSC, very aptly stated this in National Review and the State, where the learned justice said, "My lords, it is my view that the approach of this court to the construction of the Constitution should be, and so it has been, one of liberalism, probably a variation of the theme of the general maxim, ut res magis valeat cum tireat. I do not conceive it to be the duty of this court to construe any of the provisions of the Constitution as to defeat the obvious ends the Constitution was designed to serve, where another construction, equally in accordance with the words and sense of such provisions, will serve to enforce and protect such ends." Close of court. Some years down the line, in Global Excellence Communications Limited versus Donald Duke, Onogian JSC, later CJN, reiterated the relevant principle of the implementation of the Constitution, which his Lordship saying, among others, at page 19, as follows: "The principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the scope and purpose of its provisions. The words of the Constitution are therefore not to be read with stultifying narrowness." Close of court. All these were further followed by this court recently in Federal Republic of Nigeria versus Muhammadu Maigari Dingyadi in the following ways, at page 33 of the report. One main guiding post is that the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provisions. See Global Excellence Communication and other cases. There is always a need for the fulfillment of the object and true intent of the Constitution. Therefore, the Constitution must always be construed in such a way that it protects what it sets out to protect and guide what it's meant to guide. The Adeleke or your State House of Assembly. In interpreting the Constitution of a nation, it is the duty of the court to ensure the words of the Constitution preserve the intent of the Constitution. Every Constitution has a life and moving spirit within it, and it is this spirit that forms the raison d'etre of the Constitution, without which the Constitution will be a dead piece of document. The life and moving spirit of the Constitution of this country is captured in the preamble. It has been held that when a constitutional provision is interpreted, the cardinal principle is to look to the preamble to the Constitution as guiding star, and the directive principles of state policy as the book of interpretation, and that while the preamble embodies the hopes and aspirations of the people, the direct principles set out the proximate grounds in the governance of the country. This is Thakur and Union of India. In other words, in interpreting the words of Section 212(1)A of the 1999 Constitution as amended, the court should be guided by principles upon which the Constitution was established, rather than by direct operation or literal meaning of the words used in the provision, and where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned to another approach that accords with the guiding principles of the Constitution. The interpretation that would serve the interests of the Constitution and best carry out its objects and purpose must always be preferred. Close of court. Following these well-settled principles, our first port of call in unlocking the argument of the petitioners is the preamble to the 1999 Constitution and the direct principles of state policy contained therein, all of which embody the principles of the Constitution. The preamble to the 1999 Constitution loudly proclaims equality between citizens as its cornerstone, among others. Thus, we, the people of the Federal Republic of Nigeria, having firmly and solemnly resolved and to provide a constitution for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people. Do hereby make and give to ourselves the following Constitution. For those who are not used to reading preambles, the Constitution, still in its fundamental objectives and directive principles of state policy, contained in Chapter 2 of the Constitution, which this court aptly described as the road to construction in Federal Republic of Nigeria and Dingedi, repeats this equality principle. Under its social objectives provision of that chapter in Section 17 thereof, it again proclaims that 1. The state social order is founded on ideals of freedom, equality, and justice. 2. In furtherance of the social order, every citizen shall have equality of rights, obligations, and opportunities before the law. Equality of rights in every citizen, as stated in this provision, cannot by any means be read to exclude equality of the weight and value of their votes. No, it includes it. Even more so, when the issue here is the right of every such citizen to elect with their votes their president, whose policies are supposed to and will affect all of them equally, regardless of which part of the country they reside or live. So even stopping here, the futility and hollowness in the argument of the petitioners that the votes of the voters in the FCT, Abuja, have more weight than other voters in the country, to the extent of their votes purportedly have a veto effect on other votes, is rendered bare. That notwithstanding, let us still proceed to consider, for whatever it is worth, their interpretation of Section 134, subsection 2B of the same 1999 Constitution, which incidentally centers around the word "and" in that provision. In the first place, the settled position of the law is that in interpreting a constitutional provision of the court should be guided by the principles upon which the Constitution was established, rather than by the direct operation or literal meaning of the words used in the provision. And while the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned for another approach that accords with the guiding principles of the Constitution. It is quite clear that a calm reading of Section 134(2)(b) of the Constitution will leave no one in doubt that the use of the word "and" by the framework between the words all states in the Federation and the Federal Capital Territory Abuja indicates nothing more than that the framers' understandable desire for consistency in referring to the Federal Capital Territory by that name, as it is done all through the Constitution whenever reference is made to the Federal Capital Territory. The word and Federal Capital Territory Abuja do not by any means imply the meaning imputed to it by the petitioners. In any event, Section 299 of the Constitution dispels any lingering doubt that may still be existing in anyone's mind by stating that the provisions of this Constitution shall apply to the Federal Capital Territory Abuja as if it were one of the states of the Federation, then ABC. This provision states most unequivocally that the entire provisions of the Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. It is noteworthy that the punctuation mark employed by the framers immediately after the part of that provision ending with Federation, emphasized by me, is a semicolon, whose function is, in a sentence is to separate independent clauses of a compound sentence. See Merriam-Webster's online dictionary, which defines semicolon as a punctuation mark used chiefly in a coordinating function between major sentence elements, such as independent clauses of a compound sentence. Wikipedia also explains its use thus. In the English language, a semicolon is most commonly used to link two independent clauses that are closely related in thought, such as when restating the preceding idea with a different expression. The point being made here is that, contrary to the position of the petitioners, by the express provisions of Section 299 above, the provisions of the entire Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. This means that Section 134, Subsection 2B of the same Constitution, requiring a president candidate to poll at least 1/4 of the votes cast in 2/3 of the states of the Federation in order to be returned elected, means nothing more than that the Federal Capital Territory shall be taken into account in calculating the state 2/3 of states of the Federation. In other words, the FCT is no more than one of the states of the Federation for the purpose of that calculation. Nothing more than that can be implied or inferable from Section 134, Subsection 2B of the Constitution. If anything, this position is confirmed in the cases of Bakari and Ogundipe, where it was said by the Apex Court that by virtue of the provision of Section 299 of the Constitution, it is clear that the Federal Capital of Nigeria has the same status of a state. It is as if it is one of the states of the Federation. And in Ibori versus Uboru, where it was confirmed by this court that the Federal Capital Territory, Abuja, is to be treated like a state by virtue of Section 299 of the Constitution. If the Federal Capital Territory, Abuja, is to be treated like any other state, then it is not superior to or inferior to any other state in Nigeria. It is also my considered view that if the framers had wanted to make scoring 1/4 of votes cast in the Federal Capital Territory, Abuja, a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. As expressly stated in Section 299 of the Constitution, for the purposes of fulfilling the requirements of Section 134, Subsection 2B of the Constitution, for return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of states in the calculation of 2/3 of the states of Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT Abuja inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to score 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did. In conclusion, I hold without any equivocation that in a presidential election, polling 1/4 or 25% of total votes cast in the Federal Capital Territory is not a separate precondition for a candidate to be deemed as duly elected under Section 134 of the Constitution. In consequence, Issue 4 is also resolved against the petitioners and in favor of the respondents. It is right, Lord, that there is a rebuttable presumption of regularity with respect to election results, and it is for a petitioner who challenges that result to rebut that presumption with credible evidence. This settled principle was
seeking striking out the petition of portions 14 and 15, 19 to 81, 87 to 104, 108 to 128, and 133 to 150 of the petition for being fundamentally defective. The third respondent on this part in his first application on the same issue filed, we gave the date, sought similar prayers like first and second respondents. All three respondents also had issues with the replies petitioners served on them in response to their own replies. Their main complaint this time is that the said replies went beyond the ambit of replies and raised new issues and facts like particulars of the non-qualification of second respondent for the election and his dual citizenship of Republic of Guinea, all of which, according to the reply of the petitioners, impacts on his qualification as a candidate for the election. Those new facts, the complaint tended to amend or reconstruct the petition and so overreach them, even as they do not have any further opportunity to join issues petitioners on them. Other paragraphs of the replies, they said, did not raise new issues, but merely repeated averments already contained in the petition, and so have no place in the reply. For these same reasons, they sought striking out with additional statements, witness statements on oath, and list of documents that accompany the said replies. Besides the above, second respondent had a third application that was peculiar to it. In the said application, which was also filed on the 13th of May 2023, second respondent again sought the striking out of the entire petition, this time on the following four grounds: that the entire petition constitutes a gross abuse of the process of court by reason of an originating summons in suit number LCCV 354-2023, filed by the Attorneys General of Adamawa, Akwa Ibom, Delta, Edo, and Sokoto states. All of them controlled by the second respondent, as he put them, as he called them, as second respondent put it, at the Supreme Court of Nigeria against the Attorney General of the Federation, where the said plaintiffs raised against the Attorney General of the Federation the same issue here of first respondent's failure to transfer or transmit poly unit results from his BVAS to his result viewing portal IREV in the 25th February 2023 general elections. The plaintiffs wherein first respondent mentioned sought in their suit declarations that the 2023 elections were fundamentally flawed and so invalid, null and of no effect, which is what petitioners also seek here. So this petition constitutes gross abuse of process. There were other grounds for that application, as I shall show later when considering it. All 7 applications were supported with affidavits and written submissions of applicants, which were in turn countered by the petitioners with counter affidavits and written submissions of their own. I shall now proceed to consider the merits of the applications. For ease of reference, I shall group the 3 sets of applications into groups A, B, and C. I start with the first 3 applications of respondents that attacked the validity of the petition, and now its paragraph relieves claims and grounds on which it was sought. First respondent's first application, that is the one filed on 9th of April. I start with that one. First respondent set out the following issues for determination in his 9th April 2023 application. We set them out. It argues its issues 1 and 3, you get it, so there's no point arguing it, time is going. It argues its issues 1 and 2 above separately and took issues 3 and 4 together. In seeking the striking out of paragraphs 9, 2, 3, 93, all set out there, of the petition on grounds of their vagueness, imprecision, and lack of specificity to elicit a reply from it, first respondent, that is INEC, relied principally on paragraph 4.1, sub 1 of the first schedule to the Electoral Act, which states as follows. It says, an election petition under the Act
Hello and welcome to News Flash. My name is Grace Komolafe, bringing you up to speed on information within and outside Nigeria. Let's begin with Lagos. The Lagos State government has expressed its openness to collaborate with the Kingdom of Denmark in the agricultural sector to enhance food security. The Deputy Governor, Dr. Kadri Obafemi Hamzat, who revealed this while receiving the Consul General and Head of Trade of the Kingdom of Denmark, Ms. Jet Bean, during a meeting held at Alausa, Ikeja, adding that Lagos has maintained a long-standing relationship with Denmark. He emphasized the significance of agriculture as a key focus of his administration and also expressed the need to improve the management of agricultural produce to meet the high food demand in Lagos. Ms. Jet Biam, in her response, acknowledged the importance of understanding Lagos State's agenda ahead of the Nordic Nigerian Connect event. She also expressed her effort to engage Danish investors and companies in response to the Nigerian president's invitation to explore business opportunities in Nigeria. The Abia State government has refuted recent allegations of terminating the employment of 10,000 civil servants in the state. The Commissioner for Information and Culture of Abia State, OK Kanu, in an interview in Umahia noted that these claims are baseless and are without merit, adding that the government's actions were aimed at addressing the issue of ghost workers and individuals who were irregularly employed between December and April of the current year. He therefore reassured the public of the government's unwavering commitment to the welfare of its workers, both current and retired, and its determination to promptly resolve salary and pension arrears. Away from Nigeria, the Saudi Arabian ambassador to Iran has officially arrived in Tehran, marking a significant step in the restoration of diplomatic ties between the two Gulf rivals following a 7-year rift. This reconciliation, initiated by China in March, has paved the way for the resumption of all diplomatic relationships. Ambassador Abdul Al-Lanazi, upon his arrival in Tehran to assume his duty, emphasized Saudi Arabia's commitment to strengthen and broaden the relationship between the two nations. Simultaneously, Iran's ambassador to Saudi Arabia, Ali Reza Anayati, landed in Riyadh, where he was warmly received by foreign ministers, officials, and embassy staff. In less than a week, the Rugby World Cup is set to kick off in France under an intense spotlight on security preparations. The president of the public interest group responsible for organizing the Rugby World Cup, GIP, Jacques Rivoire, has since expressed confidence in France's preparedness for the event, as regular meetings with government departments and a high level of seriousness dedicated to security concerns are evident in the preparations. Learning from the previous year's ticketing challenges, measures have been taken to prevent a similar incident, with more CCTV cameras being installed around the Stade de France and closer monitoring of spectators' arrival to ensure a smooth and secure flow of fans into the venue. This tournament's success will undoubtedly set the stage for the grander spectacle of the Paris Olympic Games in the summer of 2024. Wrapping up with the U.S. news update, President Joe Biden has awarded the Medal of Honor to Captain Larry Taylor for his daring rescue mission during the Vietnam War in 1968. Captain Taylor risked his life to save 4 members of a Soviet team who were surrounded by enemy forces. Operating his Cobra attack helicopter in complete darkness, Captain Taylor responded to their desperate call for help and successfully evacuated them from imminent danger. The ceremony highlighted Captain Taylor's exceptional bravery and the challenges he faced during the mission, and praised his readiness to confront grave risk to ensure the team's survival. This Medal of Honor ceremony serves as a tribute to the valor and selflessness of individuals who have served their country in times of crisis. Thank you for staying with us on News Flash. Kindly follow us on all our social media platforms on Souk News and stay updated with all our following programs. My name is Grace Komolafe.
elections in Adavi and Okei local government areas of Kogi State by agents of second and third respondents, alleged hearing was captured in video recording which they petitioners would lead evidence in proof. Paragraph 98 of the petition, where petitioners allege that elections in 10 polling units were disrupted and there were no results from the said polling units, end quote, is bad for vagueness and specificity, insofar as it does not specify the affected 10 polling units. It is therefore also liable to be struck out. I am also of the opinion that paragraphs 99 and 100 of the petition also attacked by first respondent has to do more with proof, which is a matter for the substantive hearing, especially as the infractions complained of in them were again, according to petitioners, captured in a video recording which they promised to rely at the trial. Paragraph 101 of the petition, where the petitioner simply complained of failure of first respondents officials to properly fill election materials, seems to me sufficient pleading. Paragraph 102 of the petition, where the petitioner simply alleged that infractions occurred in polling units unidentified in various local government areas of Kogi State, and, quote, these failures enabled the results of the polling units in the said LGAs to be manipulated through and by the inflation of second respondents' votes, and the depletion of petitioners' votes is bad and vague as to the particulars of the specific polling units and votes of petitioners and respondents affected by the said manipulation of inflation and deflation. It fails to meet both the requirements of clear pleading of facts of the petition and paragraph 15 of the first schedule of the Electoral Act aforesaid. In fact, the following dictum of the lead judgment of Tabai GSC in Belgora and Ahmed clearly says so, my lord. We have already reproduced all these things in CA03, and we don't intend to read. In any case, you get it and you see it. See also PDP versus INEC. For the same reasons, I am also of the opinion that paragraph 103 of the petition, where the petitioner simply averred generally that, quote, first respondent wrongly entered incorrect results for the petitioners in Borno State, is bad insofar as the polling units in Borno State affected by the incorrect results are not stated. I am, however, of the view that paragraphs 104, 105, and 106 of the petition sufficiently plead necessary for us to elicit appropriate response from respondents, even more so as paragraphs 104 merely alleged bypass by first respondent of use of beaver machines in the presidential election in Benue State, while paragraphs 105 and 106 simply stated the petitioner's ground that second respondent was not elected by majority of lawful votes. In respect of paragraph 104 of the petition, first respondent complains that the petitioners there contended that the entire results of the presidential election were wrong, yet they did not plead the results they perceive to be correct, so it is also vague pleading. I am of the view that that complaint is better considered while considering the merits of the petition. That is even more so as it appears to us that paragraph 104 seems averred to by petitioners to meet the provisions of paragraph 4 sub 1, C of the first schedule of the electoral act that requires them to state in their petition, among other, the scores of the candidates in the election. To that extent, paragraph 104 cannot be faulted by application at this stage, let alone sought to be struck out in limine. Paragraph 105, 109, 110, 11, 12, and 113 of the petition merely pleaded facts as to whether second respondent, who by first respondent's own showing did not poll up to 25 of the total votes of the Federal Capital Territory, was properly returned by first respondent having regards to the provisions of section 134B of the 1999 Constitution of the Federal Republic of Nigeria and other relevant statutes. It is therefore in order. I am afraid paragraph 114 of the petition, 115 and 116, and paragraph 4, where they said purported results from 6,418 polling units have and indicate zero accreditation, and paragraph 118, where they avert that critically, paragraph 118 and 119 are all bad for lack of particulars of necessary facts. As for the statistician's report, again referenced by them for the said particulars, I hereby reconfirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondent, so I shall overlook it, at least for now. The petitioners in paragraph 121 of the petition allege that first respondents, presiding officers of polling units, failed to properly fill and countersign alterations in election forms, including forms EC, 8B, and blah, 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 but they did not mention the polling units, what local government and state said infractions took place. They simply reference the same statistician's report. This paragraph is bad for imprecision and so also liable to be struck out. Paragraph 122 to 125 of the petition are not challenged by respondents, so I shall skip them. In paragraph 126 of the petition, the petitioners complained that all over Nigeria, there were manifest cases of overvoting. The total of the affected polling units in the various states are set out in the statistician's report, pleaded and relied upon by the petitioners. This pleading is also, end quote, sorry. This pleading is also bad for vagueness. My earlier position on the statistician's report referenced by the petitioners is also reaffirmed. Paragraph 127 and 128 of the petition are not challenged by first respondent, so they are also skipped. I do not share the view of first respondent that paragraphs 129, 130, that's INEC, that paragraphs 129, 130, 131, and 132 of the petition are bad for lack of imprecision. Petitioners in those paragraphs carefully pleaded the specific polling units and numbers of votes therein that they claim were affected by the cancellation of elections complained by them. I am, however, of the opinion that the second complaint of first respondent against paragraph 129 of the petition, that is also deserves to be struck out for petitioner's failure to join Honorable Adejo, chairman of Oloma Boro local government of Kogi State, accused by them of having led thugs at gunpoint to force electoral officers in named polling units in Oloma Boro local government to declare concluded elections in the said units cancelled, is well made. The petitioner's response that not only was no relief claimed by them against Honorable Adejo, he did not even participate, quote unquote, in the election, neither was he returned, so it's not a petition contemplated by Section 132 of the Electoral Act to be joined to an election petition. It's not a valid response. Section 133 of the Electoral Act only deals with the issue of which contestant of an election ought to be joined in an election petition by a co-contestant. It has nothing to do with the issue of joining of third parties against whom allegations of electoral infraction are made by practitioners, as in this case. Such petitions must be joined to the petition if the court is not to be exposed to the risk of infringing their fundamental right to fair hearing guaranteed by the Constitution. It is also of no moment that no relief was claimed against such persons in the petition. What is important is that allegations of electoral malpractice, which will require the court to make findings, including condemnation of the alleged conduct, where necessary, are made in the petition. Support for that position can be found in Wankwa and Yaradua, where Muntaka Kumasi JSC, after reproducing the provisions of the then newly enacted Section 1441, sub 2 of the Electoral Act, which is now Section 1332 of the Electoral Act 2022, and confirming that that provision had done away with the old regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, said, this is what his lordship said, he said, unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is in issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party a fair hearing, end quote. As regards the consequence of failure to join such necessary parties on the petition itself, his lordship Kumasi again said as follows. However, where such a party is not made a party, it will not result into the whole petition being struck out, but the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners in the Odo State governorship case of Eitai Ojegede and another versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present head respondent APC, Governor Mei Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State, leading talks to compel cancellation of concluded elections in polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also bad for non-joinder. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria People's Party scored the majority of the lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also bad and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook Section 134, sub 4 of the 1999 Constitution, stating expressly that, and I quote, for the purposes of an election to the office of President, the whole of the Federation shall be regarded as one constituency, end quote. That is the position as it relates to a presidential election. Percentages of votes polled by presidential candidates in any of the 36 states of the Federation or even the Federal Capital Territory only become of consequence when the issue verges on whether the candidate returned also satisfied the provisions of Section 131B and 2 of the 1999 Constitution, as amended, requiring him or her to poll 25% of votes cast in at least two-thirds of the 36 states and the Federal Capital Territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. It certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested the election with him. By Section 133 of the Electoral Act, the only other candidate in the election the petitioner can properly join to his petition is the person returned as the winner of the election. See further on this, the cases of Buhari and another versus Yusuf, Yusuf versus Obasanjo and 50 others, Obasanjo and Yusuf versus others. See particularly Buhari and another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, "An successful candidate in an election cannot be made a party to an election petition against his will," end quote. We also do not agree with first respondent that paragraphs 141, 41, and 142 of the petition were vague or imprecise. But I do not, sorry. I am rather of the view that facts necessary to elicit an appropriate response from the respondents of the electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 142 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong results. For 22 name states herein, paragraph 44, where they aver that there were discrepancies on very large scale at the various local governments, various levels of recording and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where this said, quote and unquote, large-scale discrepancies took place, and paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report, among other documents they did not front-load, are bad and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground 4 of their petition that the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, quote and unquote, that is all they said, is also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. The main purpose of pleadings, as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the case is coming to meet, so that he can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. That paragraph of the petition falls far short of the requirements of paragraph 41B of the first schedule of the Electoral Act, and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that while paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahaya Bello of Kogi State accused the petition of committing electoral malpractices, paragraphs 92, 95, 98, 121, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack particulars, and so fall short of the requirements of paragraph 41B. They are all therefore ordered struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 100, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140, on the other hand, are in order and properly pleaded. Now, issue 2 of first respondent in this same application reads whether, having regard to the mandatory provisions of paragraph 41B of the first schedule of the Electoral Act, a reasonable course of action has been disclosed in respect of grounds of the petition contained in paragraph 16A, B, C, and D of the petition to warrant further or any adjudication on same. Counsel, on behalf of first respondent, this time anchored the arguments principally on the grounds on which the petitioners founded their petition. Counsel reproduced paragraph 16A, B, and C of the petition, where the petitioners alleged, we set them out. The next reference, section 134 of the electoral law, stating that an election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135(1) to the effect that an election shall not be liable to be invalidated by reason of non-compliance with the provisions of the Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and the non-compliance would have substantially affect the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf as a judge, learned counsel submitted that for petitioners to sustain their ground of corrupt practice and non-compliance of the election with the provisions of the Act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complained of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and that the deduction of such votes would void the return of second respondent as the winner of the election. They said not only did the petitioners not assert in their petition that the non-compliance complained of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court to form an opinion on that non-compliance and corrupt practices complained of substantially affected the result, or that second respondent polled majority of lawful votes in the election and so ought to be returned. Without those facts in the petition, the petitioner's counsel submitted have simply blown quote-unquote muted trumpets and their petition lifeless and failed to disclose a substantial cause of action, so it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, the petitioners have averred that the election was not conducted in accordance with the provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election, in that the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, the first respondent first application. Counsel to first respondent their issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition to submit that the petition, as by reason of the alleged omission in the petition identified above, had become academic and constitute abuse of process of court, so this court is robbed of jurisdiction to entertain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issue 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application, seeking dismissal of paragraphs 14 and 15, 19 to 81. Okay. We didn't quite write it that way here. For this application, learned counsel second respondent simply said that the sole issue for determination, thus, which was that in view of the provision of paragraphs 14(1)(d) of the first schedule to the relevant Electoral Act and relevant judicial decisions, whether paragraphs 14 and 15, 19 to 81, 87 to 104, 527, and 108 of the petition are not liable to be struck out. We set out the arguments, both of them. We said, in the course of determining first respondent's application on the same issue of vagueness and precision in the complaints, I dwelt extensively on the rationale for exchange of pleadings, generally and particularly in election particulars, as further set out by the lawmaker. I hereby adopt all those pronouncements. In the same exercise, I also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petitioners, paragraphs 92 to 146 of the petition, also made by the second respondent here, I there determined, we said what we did, and we said, I abide by those findings. I shall therefore simply focus on paragraphs 14 to 19 and 147 to 150, and the few paragraphs between paragraphs 92 to 147 of the petition omitted by the first respondent in the application determined the complaints of second respondent of whether petitioners' complaints in those paragraphs were vague, imprecise, and generic. I now start that exercise without prejudice to what I had said earlier, and which I hereby reconfirm on the invalidity of the statistician's report relied on by the petitioners for particulars of the averments in the petition. I am of the opinion that paragraphs 14 to 15 of the petition, where the petitioners specifically complained only about correctness of the contents of INEC forms, are so clear as to the issue raised and so not vague. Paragraph 16 of the petition are not attacked by first respondent and so are also skipped. We also do not find paragraph 20 to 20 of the petition where the vague. We do not also find paragraphs 20 to 20 of the petition where the petitioners complained that first respondent did not keep to its earlier promise of electronic transmission of election results to its IREF portal in real time when it returned this in vague. We, however, find vague, imprecise, and falling far short of the requirements. I, however, find vague, imprecise, and falling far short of the requirements of paragraphs 4(1)d and 15 of the first schedule of Electoral Act 2022, the amendments in paragraph 23 of the petition, where the petitioners complain that the result of the election as announced by INEC does not represent lawful votes, and that lawful votes cast for them were massively deducted from their scores. Those paragraphs ought to contain the lawful votes of the petitioners that were alleged, quote, massively deducted, as well as those alleged to have been allocated to second respondent by INEC. We find properly and sufficiently pleaded paragraphs 24 down to 72 of the petition. We, however, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complain that permanent voters' cards collected in unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first petitioner and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading ought to contain the precise number of permanent voters' cards alleged collected in the polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in the conduct of the election, which practices they complain took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes, is vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of the petition, less paragraphs 135 and 36, also complained of by second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We hereby adopt our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondents' votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, even the petitioners again complained that the votes returned by the first respondent for Obi Akpo and Port Harcourt local government areas of Rivers State did not reflect the actual votes, did not express the actual votes scored in the said local government areas, or even those updated to IREF by INEC and so liable to be voided. No correct quote-unquote figures of the actual votes cast as reflected in the IREF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. The sum total of the foregoing are complaints of vagueness, imprecision, and genericness of amendments, all by second respondent against the petitioner, only made out as regards paragraphs 23, 82 to 86, 89 to 91, 92, 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of the petition are deemed in order and pass the vagueness test of paragraph 4(1)d of the first schedule of the Electoral Act. In pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out. We are, however, of the petition that application for particulars is only one of several options open to second respondent, who in any case is not under any obligation to help petitioners make out their case against him by asking for particulars of their generic and nebulous complaints. That is also the point that was made by Fabi EJS in PDP versus INEC, when his lordship said at page 524 that, and I quote, the application for another for further particulars or the like is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, or devoid of necessary particulars. The decision in Olawekpo versus Saraki, cited by learned counsel on both sides, is in point. It is not the duty of a respondent to groom a petitioner on how to draft his petition, end quote. It is also quite revealing, if not even reassuring, we must say, that this argument of the petitioners of duty on second respondent to ask for further particulars, because that's their main argument, in their petition rather than asking for striking out the particulars, was also rejected by Muntaka GSC, while delivering lead judgment in PDP versus INEC in 2012. Even as the same argument had found favor with his lordship, that is Muntaka, 2 years earlier in his contribution in Nwankwo versus Yaradua. His Lordship, in the latter case of PDP versus INEC, endorsed the stand of trial tribunal in that case that paragraph 12, sub 5 of the first schedule to the Electoral Act, same as paragraph 12.5 of this present Electoral Act, 2020, sorry, okay, permitting respondents to apply to strike out a petition did not exist in the 2000 Electoral Act in force at the time Nwankwo and Yaradua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to IRF portal in real time, was caught and made comatose by Section 134 of the Electoral Act, stating Electoral Act. We think it is, I think it is neater and even safer to defer it to the main argument for determination on its merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again Nwankwo and Yaradua, citation given. Third respondent's application on the same issue of vagueness of paragraphs. It is our own application, that is the third respondent this time. It is own application of 8th May, third respondent, like the first and second respondents, also plead us to strike out all of paragraph 17 to 146 of the petition on the same grounds of vagueness, imprecision, blah, 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 and failure to join Mr. Adejo and Governor Yahaya Bello of Kogi State, against whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners' averments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this court, sitting as an election petition. Again, the petitioners argue in response that their complaints were properly pleaded in the petition, so not imprecise nor pre-election matters as alleged by third respondent. Resolution. Since the application of third respondents relates to the same paragraph of the petition objected to by first and third respondents, over which we have already made findings, we abide by and adopt those findings in determining the application of third respondent. We further hold that petitioners' averments in paragraphs 19, 20, 21, 35, 41, 42, and 45 of the petition are not pre-election matters. In fact, whereas issues of the assurances given by INEC of real-time transmission of results to IRF raised by petitioners in paragraphs 19 and 20 of the petition, how the elections were generally funded by the federal government of Nigeria on account of those assurances as averred, and how first respondent transferred his in-house expert from one department to another before the election as alleged in paragraph 35 of the petition, cannot by any means give rise to a cause of action, let alone a reasonable cause of action. In petitioners, what is here? In petitioners, the averments in paragraph 42, 43, and 45 of the petition are simply notices by the petitioners to subpoena witnesses to testify about first respondents' omissions and commissions in the conduct of election, and so cannot by any means be described as causes of election, let alone pre-election matters for which they could have commenced action as alleged. In conclusion, the applications of first, second, and third respondents succeed only partly, and the following orders are made on them. Paragraphs 23, 82 to 89, 88 to 91, paragraph 95, 95, 98, 121, 124, 126, 129, 133, 135, 136, 143, 144, and 146 are hereby struck out as prayed. The remaining paragraphs of the petition attacked past the vagueness test and paragraph 41D of the first schedule of the Electoral Act 2022 and are hereby upheld. That leaves us with the standalone application of third respondent, also filed on 8th of May 2023, as well as the three applications of third respondents, all objecting to the petitioner's replies to their petition, to their reply, sorry. Second respondent, so we take that one. We try to produce the arguments there. We said, and then we went on to say that the thrust of the response of petitioner's counsel, that is 45543. The thrust of the petitioner's counsel is a suit number SCV-CV351 that was not filed by the petitioners. So this petition, sorry, okay, I'm still reading. It's 544. Said now it is settled position of the law that once a court is satisfied that a proceeding before it amounts to abuse of process, it has the right and indeed duty to invoke its coercive powers to punish the party in abuse. Quite often that power is exercised by dismissal of the action that constitutes abuse of process. But multiplicity of actions, which is the complaint here, on the same subject matter and issue will only constitute abuse of judicial process if the parties in both actions are the same or previous to one another. See Okafor vs. Attorney General of Anambra State. It necessarily has to be so because except where a person is shown to be privy of another as recognized by law, no man can be punished for the actions or sins of another. That is the crux of the issue here. It is whether the petitioner, that's Atiku Abubakar, and his political party, the PDP, can be properly described as privies of the governments of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states, who undisputedly instituted suit number SCCV against the Attorney General of the Federation before the Supreme Court of Nigeria. That question can only get a negative response. For the government of a state, regardless of the political party platform on which its executive governor is or was elected, represents all shades of opinion in the state, including even those who may not belong to any political party at all. In fact, a state government is not even bound nor obliged to take instructions from the political party of the governor. Interestingly, our law reports are replete with cases where state governments elected on the same party platform with the federal government have repeatedly sued the federal government at the Supreme Court. A good example is this. Okay. A good example is the recent new currency case. Which one is that? 581? Yeah? It's a new currency case that was instituted by the Attorneys General of Kogi, Kaduna, and Zamfara states against the federal government, even as both parties were APC governments. In that situation, one wonders where counsel would place this proposition of privity by affinity. There are other cases, we cited them, so we go on and on. In short, we reject this argument of second respondent of abuse of judicial process on account of litigation commenced by state governments against the Attorney General of the Federation. That is, as we also take note of the notice of discontinuance of case, the said suit number SCCV 354, 2023, filed by the plaintiff in that case since the 3rd of March 2023, which notice was tendered by the petitioners in this court as Exhibit PV in the course of the hearing of the main petition on the 6th of June 2023. This court is obligated by Section 1221M of the Evidence Act to take judicial notice of its proceedings. The other argument of note of second respondent in this application is the one of failure of petitioners to again join Friday Adejo and Yahya and its effect on the petition. We have already struck out the relevant paragraphs of the petition where allegations of malpractice were made against the two gentlemen. We abide by that decision. We shall simply add that we do not agree with second respondent's argument that the entire petition merits dismissal for non-joinder of those two men. The proper sanction in circumstances of this case, as we have already pointed out, citing Wankwa and Yaradua, is to strike out the paragraphs of the petition where those allegations were made. That order will also further add, and contrary to the argument of second respondent, will not affect the paragraphs where allegations were made against unnamed thugs. Unnamed persons cannot be joined to an election petition like it is sometimes done in trespass cases. See Obasanjo and Yusuf, where a similar argument was rejected out of hand by Kutigi and Pastor Chalon on JSC. Thus, it was said there that it said, quote, it is impossible to drag unknown touts, police, and hordes of others to court and join them. That would be bizarre, end quote. So, okay. So the next one, we now go to the challenges, the replies filed by the petitioners. All three respondents also challenge the validity of the replies and the accompanying witness statements on oath and list of documents petitioners served on them in response to their replies. Their common complaint in those petitions is that the said replies or paragraphs thereof offend paragraph 16 of the first schedule of the Electoral Act governing filing of replies by the petitioner and so liable to be struck out. First respondent's objection was against the reply of first petitioner that was served on it. They are sought striking out of paragraphs 1.1, 21, 23, and 21 of the petitioner's reply, striking out the further witness statement on oath of DM, who later revealed himself in the production as Senator Dino Melaye, and PDPC both deposed on 20th April, striking out the petitioner's list of additional documents dated the 20th day of April, which accompanied it. Sorry. The thrust of the argument, which is counsel founded principally, and we reproduced the arguments, and we reproduced the reply. To start with, I am not persuaded by the petitioner's argument that the new facts or issues raised by them in their impugned reply relate to non-qualification, which is one of the arguments, and not the conduct of the election by first respondent. So second respondent, who is supposed to be first respondent, that is INEC, who is supposed to be neutral in that matter, cannot be heard to be objecting to them. The issue raised by first respondent, that is INEC, actually relates to the competence of a major process before the court, to which the reply filed by petitioners. It is an issue which counsel to first respondent as ministers in temple of justice, and even first respondent itself as a party to the petition, have a duty to bring to the attention of the court. That obligation even becomes more pronounced when it is realized that a substantial number of first respondents counsel are members of the inner bar who even have greater responsibilities to the court by virtue of their ranking. This preliminary objection, like the argument of the petitioners, is therefore rejected. 543. Coming now to the merits of the application, it is common ground that the provisions of the electoral act most relevant to the resolution is paragraph 16 of the first schedule. We reproduce it. This provision, with the employment of the word shall, forbids the addition of new facts, especially if such new facts may have the effect of tending to amend or even just adding to the contents of this petition. We cited cases, and I think we have spoken on it in 03. Incidentally, this paragraph also reflects in the case of this sin only restates the well-settled position of adjective law that the claimant's claim or grievance are made in the statement of claim or petition as the case may be, and not in his reply to the statement of claim to that claim, statement of defense to that claim. That position also finds expression in Olubodu and Lawal. We cited what the Supreme Court said there, where it said a plaintiff must not in his reply make any allegation of fact or raise any ground of claim different from what is contained in the statement of claim. If a plaintiff does such a plea is irretrievably bad, and no evidence would be admissible in his proof, end quote. In fact, that settled position of law is that except in some well-defined situations, a reply to a statement of defense is not even permitted where no counterclaim is served. This is so because there is in law an implied joinder of issues on any fact raised in the statement of defense, and any averment contained therein is deemed denied, cases cited. As to what will amount to a new issue, we cite again Egesimba versus Nuzurike, earlier cited in appeal number 03. Guided by all these and paragraph 16(1)(a) of the first schedule, it does not by any means appear to me that the new facts of conviction, conviction/fine, forgery, and dual citizenship of second respondent introduced by petitioners into their reply. The additional averments of how results could not have been uploaded to INEC's IREV after the 25th of February, and C, whether it was done at all and relevant officials of INEC could not have been involved in it, not to talk of the repetitions reply of averments already made by petitioners in their petition can pass as reply filed pursuant to paragraph 16(1)(a) of the first schedule of the Electoral Act, particularly as relates to the further details as are quote and unquote, as petitioners labeled them in their reply, of non-qualification of second respondent contained in paragraph 2(1)(b) of their reply. It bears reiterating that all that the petitioners revert to in paragraph 146 of their petition is the bare statement that, quote, the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, unquote. No details whatsoever was given by them of what they meant by second respondent's non-qualification. So first respondent, who was obviously satisfied that second respondent was qualified to contest the election by the documents he presented to it, also simply joined issues with them in a similar general manner. It is now through their reply that petitioners, who themselves seemed to have had no clear idea of what they meant by second respondent's non-qualification for the election, or simply deliberately kept it back when filing their petition, want to now introduce through their reply at a time when respondents have no further right of responding to them. Such unfair tactics cannot and is not allowed by our law. It must be noted, too, that under Section 131 of the 1999 Constitution of this country, there are as many as 4 different qualifications a person must possess before he can contest presidential election, and another 10 different grounds that can qualify such a candidate who has all the 4 qualifications of Section 131. Therefore, an assertion that merely says that a person is not qualified to contest election by reason of non-qualification will leave not just the person so assailed, but every other person involved, including the court, at a loss as to what the pleader has in mind. In fact, to allow such pleading will amount to upsetting the very essence of filing pleadings in a case, which is to give the adversary and the court a clear notice of the pleader's case, a point further fortified in paragraph 61(a) of the first schedule to the Electoral Act. Still on this issue, I must not fail to point out that the petitioners were only being clever by half when they claimed in paragraph 2(1)(b) of their reply that they were simply giving, as they put it, further details, quote and unquote, of the non-qualification of second respondent by averring to the conviction, fine, certificate, forgery, and dual citizenship of second respondent that they raised in their replies. They had never given any details of second respondent's non-qualification, and so cannot talk about further details, quote and unquote, let alone hide under such further details to smuggle in the new facts they have had in paragraph 1B of their reply. These new allegations are not also mere, as they call it, evidence in support of their ground of his non-qualification, as their counsel also tried to make them out. They are facts which can only be contained in the petition itself, and not in the petitioner's reply to respondent's defense to the petition. Paragraphs 2(1)(b) and C of the reply, where petitioners have had to no uploading of polling unit results by first respondent, presiding officer at the election, we also agree with first respondent, are new issues or at least mere further denials by the petitioners to respondent denials of the petition. Such is not also permitted in the reply. See again Bakar and another versus Ibrahim, Akeredolu versus Akinremi, Egesimba versus Nuzurike, Spasco versus Alrain, Ishola versus LGBN, or both versus CBN. In the light of all the foregoing, the two witness statements as well as list of documents accompanying that reply, all of which were based on the new facts contained in the impugned paragraphs of reply in issue, are also incompetent and liable to be struck out. In summary, first respondents' applications of 9th May succeed in its entirety. Accordingly, paragraphs 1, 2, we stated them of the 1, 2, Roman figure 1, Roman figure 2, Roman figure 3, Roman figure 4, Roman figure 5, and 2(1)(b), 2.1(b), C, and D of the petitioner's reply, filed in response to the reply of first respondent together with the two witness statements on oath and list of documents which accompany that reply are all hereby struck out. Second respondent's application seeking striking out the self-respondents. Learned counsel also made his arguments, our arguments, and then we come straight to the resolution. And I said here, my Lord said here, that I'm not even in the least persuaded by the argument of the petitioners, that they simply reply to new issues raised by second respondents in reply to their petition. The petitioners, like they did in their reply to the reply of first respondent, introduced fresh facts and issues of non-qualification of second respondent on grounds of his alleged criminal conviction, forgery of documents, and dual citizenship. That is foul play, which paragraph 16 sub 1A to the first schedule of the Electoral Act expressly forbids. Consequently, paragraphs 1B1, Roman figure 7, A, B, C, and Roman figure 8 of part 1, as well as paragraphs 2, 3, Roman figure 1, 2, 3 of part 2 of the reply of petitioners. The second respondent, where the petitioners avert new facts of purported criminal conviction for future proceedings against second respondent adverse to his purported dual citizenship or grounds of non-qualification, are all hereby struck out. Paragraphs 8, 11, Roman figure 1, 24, and 24b of the petition we hold on the state of the authorities earlier considered are also new facts or at best mere denials and so liable to be struck out too, as they do not qualify as replies. Bearing the above, all other paragraphs of the petition filed on the 23rd, petitioner's reply filed on the 23rd of reply 2023 stand either not objected to or the complaints against them are not made out. In other words, the application of second respondent also succeeds partly as stated above. Third respondent's application as relates, now we come to third respondent's application, and we come straight to say that I find necessary to first observe that like all other replies of the petitioners, the impugned reply of petitioners of 24 that was served on third respondent is in parts A and B. Part A is devoted solely to the preliminary objection raised by third respondent's reply to the petition. That part is understandably not challenged by third respondent, so it shall remain as it is. It is only part B of that reply that is challenged by third respondent, and it's also this part that contains in its paragraphs 32 and 33 the fresh facts of second respondent's alleged status as ex-convict and having dual citizenship, all of which now insist disqualified him as a candidate for the election. These facts I have already determined can only be raised in the petition and not in their reply to the respondent's reply to their petition. They therefore offend paragraph 16A stated above. Besides these two paragraphs, every other amendment in paragraph 2 of the reply, bar last paragraph 35, are, as third respondent's counsel rightly pointed out, either mere denials of third respondent's reply to the petition or repetitions of petitioners' amendments in their petition, and so not permissible in a reply as per paragraph 16AB, 1A of the first schedule of the Electoral Act. See again the cited cases. It's also not the law, as erroneously argued by petitioners' counsel, that failure to reply to facts averred by third respondent in his reply to the petition would mean admission of those facts. And somehow counsel like arguing always like that, not just this one. Failure to deny averments contained in a statement of defense does not imply admission, like it does with failure to deny averments in a statement of claim. See again Simba's case, Ayola GSC, I cited this thing. In summary, third respondent's application succeeds in its entirety. Consequently, barring paragraph 35, the entire part B of the reply of the petitioner's reply of third respondent is incompetent and is hereby struck out. That concludes and settles all 7 applications trust preliminary objections of respondents. So that is it. So I now hand over to my leader, as politicians who want to call it, so that my Lord can continue to take over from there.
We'll go to the respondents' objections to documents tendered by the petitioners at the trial. My learned brother, by my immediate right, will read the ruling.
Right. Thank you. We want to take on the respondents' objections to documents tendered by petitioners at the trial. In the course of the hearing of this petition, objections were raised by the three respondents. First, to the validity of the witness statements on oath deposed to by some of the witnesses of the petitioners. Specifically, PW12, that is petitioner's 12th witness, Eguma Friday. PW13, that is Grace Timothy. PW14, Grace Ajagbona. PW15, Abidemi Joseph. PW16, Ms. Edosa Obasa. PW17, Ms. Aleri Ayuba. PW18, Ms. Sadia Mohamed Haruna. PW21, Mr. Samuel Odunta, a statistician. PW23, Janet Nuhu Turaki. PW24, Christopher Bulus Ado. PW25, Victoria Sani. PW26, Hitler Egwonu Nwala, a forensic expert. And PW27, Mr. Mike Enahoro Eba, a legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties, and the ruling on it deferred by the court till final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents. And now proceed to consider the said objections of respondents. 1, the validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, that did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by First Respondents' Counsel on 8th of June 2023, when PW12, Mr. Eguma Omachono Friday, a presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June 2023, long after the filing of the petition, and even after hearing of the petition had commenced, Respondents' Counsel again raised and adopted the same objections against those witnesses and their witness statements. As explained earlier, the thrust of the objection, which was championed by Chief Wale Olanikwekwe SAN for second respondent, was anchored on paragraph 45B of the first schedule to the Electoral Act 2022, requiring that the election petition shall be accompanied by, among others, witness statements on oath of the witnesses the petitioner intends to call in proof of the petition. Learned Counsel argued that insofar as the witness statements on oath of the said witnesses of the petitioners did not accompany the petition of petitioners as required by paragraph 45B and 6, sub 6 and 7 of the first schedule to the Electoral Act, they were incompetent and cannot be relied on by petitioners or the witnesses concerned. It is irrelevant. It's irrelevant. Counsel argued that the said witnesses came to testify on subpoena issued to them by this court as paragraph 45B of first schedule to the Electoral Act makes no distinction between ordinary witnesses and those who were testifying on subpoena. Then that argument was taken, and after hearing the argument, this is our resolution. Now, this contention of the respondent has far-reaching consequences, as its resolution in favor of respondents will result in the court discountenancing the evidence of all the presiding officers, namely PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who were in the polling units in the election, and so were eyewitnesses to the alleged failure by INEC to transmit and uphold the election results to IREV, a major pillar of the petition. It will also result in discountenancing the evidence, oral and documentary, presented by petitioners' two expert witnesses, PW 21 Samuel Odunton and PW 26 Hitler Nwala, but also their last witness, Mike Enauro-Eba, PW 27, who alone testified on the non-qualification of second respondent for the election and tendered documents in that direction. That is, even as we must not fail to remind ourselves that the relevant facts in the petition and replies of the petitioners that would have supported the evidence of PW 21, 26, and 27, Mr. Samuel Odunton, Hitler Nwala, and Mike Enauro-Eba, have already been found incompetent and struck out by this court while ruling on the applications like preliminary objections of the respondents. Coming back to the objection of the respondents that paragraph 45B of the first schedule to the Electoral Act 2022 does not make any dichotomy between ordinary witnesses and those testifying only on subpoena as regards the duty to front-load witness dispositions along the petition. So the evidence of PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, whose witness statements or note were not front-loaded with the petition are incompetent. Paragraph 45B of the first schedule to the Electoral Act 2022 reads thus, and I want to mention it. It says, the election petition shall be accompanied by B, written statements on oath of witnesses. And clearly, this provision, particularly the word witnesses, whose written statements on oath the lawmakers require that shall accompany the election petition, must be given its literal interpretation. See the recent decision of this court in Ogba and Vincent, and then that of Senator Ararumi and INEC, all citations supplied. The unreported decision of this court also of 17th of July 2020 in Advanced Nigeria Democratic Party ANDP versus INEC and two others, appeal number EPT 406/2020, and People's Democratic Party versus Okogbo, citation supplied on the issue. Where the words of a statute or instrument are clear, like paragraph 4.5b of first schedule to the Electoral Act is, particularly the unqualified witnesses, in quote, employed there, the court has no duty than to give it its literal meaning. Now, in Advanced Nigeria Party, Democratic Party, NPA versus INEC, in appeal already cited, presided over by Justice Igenimpa and Agim, her colleagues, as Agim as he then was unanimous in his decision on the point in issue. JCA, pronouncing the leading judgment, said, I am of firm view that if Section 145 of the Electoral Act 2010 and paragraph 34554 of the first schedule to the Electoral Act 2010 are juxtaposed with Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, it is eminently clear that Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules is outrightly inapplicable to the situation the appellants find itself in this case. Paragraph 3 and 4 of the first schedule to the Electoral Act 2010 contain express and adequate provisions as to what the contents of a petition should be and the documents that must be front-loaded and accompany an election petition, including a list of witnesses that the petitioner intends to call in proof of the petition, and more importantly, written statements on oath of witnesses. Well, there is also, it says further, there is no dichotomy between witness statement mentioned in paragraph 4.5 of the first schedule to the Electoral Act in respect of witnesses' statement on oath of witnesses and witnesses' statement on oath of a subpoena witness. There is no distinction between ordinary witness and subpoena witnesses under paragraph 4.5 of first schedule to the Electoral Act. In essence, paragraph 4.5 of first schedule to the Electoral Act covers witness statements on oath of all categories of witnesses the petitioner intends to call at the trial of his or her petition, unquote. In Senator Ifeanyi and INEC, this court also, decided over by my Lord Justice Samani JCA, the concurrence of my brothers Owade Kimbami, Bolaji Yusuf, and Bayero JCA, again confirmed this position when, in that decision, it was held. Learned counsel for the appellant has argued that PW2 was before the court on subpoena, therefore the tribunal could not turn around to prevent him from testifying. It is not disputed that the said witness was before the court on subpoena ad testificandum, but it must be realized that the witness was subpoenaed on the application of the appellants. He was not summoned by the tribunal in the exercise of their powers pursuant to paragraph 41, 5, and 6 of the first schedule to the Electoral Act. He was therefore, for all intents and purposes, witness for the appellants. In that respect, his written statement or note was subject to the requirements of the law as stipulated by paragraph 4.5 of the first schedule. Strict compliance with paragraph 4.5 of the first schedule to the Electoral Act is mandatory. It is of such a nature that there is sanction in subparagraph 6 of paragraph 4. This point was also earlier made in petition 03. Also see the decision of PDP and Okabwe, and then Ogba and Vincent, Midira and Patricia Ete, Awoyemi, Lasun and Awoyemi. All these cases have their citation here, and they already referred to in our earlier 3. Okay. It is of interest that in all these cases, the earlier decisions of this court, Midira versus Patricia Ete and another, and Lasun versus Awoyemi, relied on strongly by Mr. Chris Uche, SAN, for the petitioners were cited and considered but departed from by this court. Quite remarkably too, in his book, Modern Nigerian Election Petitions and Appeals Law, published in November 2017, which book Chief Chris Uche, SAN, the lead counsel for petitioners herein, wrote a glowing forward to. The learned author, Mr. Kelechi Peter Ikoroga, Esquire, had this to say at pages 134 to 140 while commenting on this same issue, the SR position of this court in Omidira and Ete, and then Lasu versus Awoyemi. There, Chief Uche SAN, who is incidentally is present here, says, just like a petitioner in an election has 21 days from the date of the result of the petition to file his petition, otherwise such a petition becomes statute bar, there is also a time limit to the period within which a petitioner is to file a deposition or other document not filed along with the petition. Thus, all evidence required in proof of a case must, as a precondition to exercise jurisdiction, be brought within the stipulated time frame. That is to say, 21 days after the declaration of the result. The Supreme Court has consistently, in the long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. Thus, the efficacy of the decision of Omidiron versus Ete, see also Lasso and Awoyemi, citation supplied, wherein the Court of Appeal held that it would be appropriate to omit the justice of the case for a tribunal to order the filing of witness depositions by subpoenaed witnesses outside the stipulated time frame has been watered down, in that all evidence required in proof of the case must be brought within stipulated time frame. See the case of Ogba and Vincent, where the Court of Appeal, Agim JCA, as it then was in lead judgment, held, I think that this court in Omidira and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or a court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election proceeding. Omidiron's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006, the provisions in the first schedule thereto in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1(1) of Election, Tribunal, and Court Practice Directions 2006, and the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic approach of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the election tribunal, and court practice directions in the rules of court in election cases. In Oke versus Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The law has laid out strictissima juris in Oke and Mimiko is that a witness deposition that is not filed along with the petition within 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus: if there was evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition, even if it was being withheld by any person. There are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this, and the petitioner ought to have resorted to that procedure. Put this in italics, we have earlier mentioned it in 03. As earlier said, Chief Chris Uche SAN, in his foreword to that book, glowingly endorsed this author's position and even recommended it to judges like us in these words: the author has ably and remarkably sought to examine the legal framework of electoral legislation within the landscape of judicial decisions emanating from disputes arising from elections in the context of election litigation, from the preparation of the election itself through the pre-trial proceedings, the actual trial, the judgment and trial proceedings. This book truly stands out in the midst of several other books in this field. As an avid participant in electoral litigation, I wholeheartedly recommend this book to all, particularly to lawyers, judges, students of electoral laws, litigants, and as well as all stakeholders in the development of our constitutional democracy, unquote. I shall hold counsel to his words, not just because they are coming from him, but also because they are correct. Permit me to still say a word or two on petitioners' contention that Order 3 Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019 permitting parties to file witness deposition of a subpoenaed witness even after commencement of the action applies automatically to election petitions by virtue of paragraph 54 of the first schedule to the Electoral Act 2022. So witnesses' statement as said of their witnesses filed by them after hearing of the petition had long commenced wherein were in order, We'll stop. In the first place, paragraph 54 of the first schedule to the Electoral Act simply states, subject to the express provision of this Act, the practice and procedure of the tribunal or the court in relation to election petitions shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modification as may be necessary to render them applicable having regard to the provisions of this Act, as if the petitioner and the respondent were respectfully the plaintiff and the defendant in an ordinary civil action. This provision clearly makes application of the civil procedure rules of the Federal High Court in election petitions subject to the express provisions of the Electoral Act. It is not the other way around of modifying provisions of the Act to agree with the rules of the Federal High Court as suggested by Petitioners' Counsel. That much, paragraph 54 further clarifies by stating that even where the Federal High Court rules are considered applicable, they shall only apply with such modifications as may be necessary to render them applicable having regard to the provisions of this Act, unquote. What all that means is that where there is express provision in the Act on a particular situation, such as it clearly is in paragraph 45B of the first schedule to the Electoral Act 2022, that says the election petition shall be accompanied by written statements on oath of witnesses, the provisions of the Federal High Court Civil Procedure Rules will not apply. Fortunately, there is again high authority in support of this position in the dictum of Muntaka Kumasi GSC in Nwankwo versus Yaradua, citation supplied, where His Lordship, after producing paragraph 50 of the first schedule to the Electoral Act, now paragraph 54, had this to say. Say from the above, it is crystal clear that the provisions of the Federal High Court rules are subject to the provisions of the first schedule of the Electoral Act 26, and if there is any conflict between them, the provisions of the rules under the Electoral Act will prevail. It is where there is a lacuna in the provision of the rules provided in the Electoral Act 2006 that the provisions of Federal High Court rules will apply. I shall also add that the Parliament have expressly stated without dichotomy in paragraph 45B of the first schedule that to the Electoral Act that petitioners shall front-load witness statements of their witnesses along with their petitions. It is not within the province of the court to give that provision a different interpretation. It is also no moment that in the court's opinion, the say literal meaning of paragraph 45B of the first schedule to the Electoral Act 2022 seems harsh and may not meet the justice of the case, as is being suggested by the petitioners that subpoena is only issued to an unwilling witness, so it is not contemplated by paragraph 45B of the first schedule to the Electoral Act 2022 that a witness on subpoena should also depose to a witness statement before the subpoena to compel the attendance is served on him by the court. If anything, the argument rather brings to mind the very strong admonition of the British House of Lords of Lords, Lord Denning MRL in Dewport Steels Limited versus SIRS, citation supplied, where the learned Lord Scaman in his speech said, but in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law, not to change it to meet the judge's idea of what justice requires. An interpretation does, of course, imply in the interpreter a power of choice where different constructions is possible. But our law requires that the judge chooses the construction which, in his judgment, best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Unpalatable statute may not be disregarded or rejected merely because it is unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits his idea of what justice requires in any case. That is a settled position of the law, even in this country. See Ndomaegba and Shukwogo. Citation supplied. Aromolara versus Aguru. Coca-Cola, Nigeria, Akinsanya, then Global Excellence, cited earlier, and Donald Duke. There, summarized aptly, wherein my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new Section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management through pre-hearing session as effectively as possible, to carefully plan the future course, and particularly its plenary hearing of every petition, so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Okogbu, and others, citations supplied, where my colleague Abadwa JCA said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties, and open the floodgates for all kinds of abuses of the judicial process, unquote. I think the same point is also deducible from the following. In the dictum of Toby mentioned similar things in Buhari and INEC, and then Buhari and INEC also said a lot about that. We have mentioned it earlier. And then by rules of stare decisis, the decision in Oke and Mimiko and Ogba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor Rusek and ACB is there, and then ITPP Limited and UBN Limited. See the decision of Ogbuagu JSC. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW12 Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajagbona, PW15 Abidemi Joseph, PW16 Ms. Edosa Obosa, PW17 Ms. Aleria Ayuba, PW18 Ms. Sadia Mohamed Aruna, PW21 Mr. Samuel Odunta, the statistician, PW23 Janet Nuhu Turaki, PW24 Christopher Bulusado, PW25 Victoria Sani, PW26 Hitler Ewonu Mwala, forensic expert, and PW27 Mr. Mike Enauroeba, legal practitioner, which did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. The further consequence of that decision is that, given the provision of paragraph 41 sub 3 of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It follows that all the evidence, including evidence in cross-examination and all documents, reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, PAR1C, PAR1D, PAR1E, and PAR1F, and PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2, 1A, PBD2A, PBD3, PBD4, PB1, PBE2, PBE3, PBE4, PBE5, PBE6, PBF1, PBF2, PBF3, and PBF4, coming from and tendered by the said petitioner's witnesses, namely, as I already listed, PW 12, 13, 14, 15, 16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned are incompetent and are hereby expunged from the records of this court. Other objections of respondents. That takes me to the other objections raised by the respondents to the admission of documents tendered by petitioners at the hearing, which objections they only gave notice that they will give reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to those objections. Now, before going into the objections, we deem it necessary to first dispose of the preliminary argument of counsel to petitioners that some of the documents objected to by respondents are electoral material certified by the first respondent INEC, which documents parties had agreed at the pre-hearing session that they will not object to. So respondents cannot resile from that agreement and raise objection as they are doing. They even cited Section 169 of the Evidence Act 2011 to say respondents are stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it, and it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See Shano and AfriBank and other authorities in that respect. As counsel, as ministers in the Temple of Justice, are therefore within their right and in fact duty-bound to draw court's attention to that fact, regardless of whether or regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I would have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Counsel to the first respondent in paragraphs 1.34 to 1.36 of first respondent's written address filed on 14th of July 2023, second respondent at paragraph 3.13 of his 20th of July 2023 address, and third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023, all argue that that payment for certification is one condition precedent under Section 104 of the Evidence Act 2011 for certification of public documents. They said petitioners did not pay for certification of some INEC documents, specifically exhibits PAJ1, PAJ 37, PAJ 38, PAJ 39A to F, PAJ 40, PAJ 41 to PAJ and PAJ 41 to PAJ 7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAX13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any evidence of payment of certification fees. Learned Counsel, all citing the cases of Tabik Investment and GTB, Jimon, Minister of Federal Capital, Emeka and Chuba Ikpeazu, argued that certification fees for the said documents having not been paid by the petitioners, the documents remaining admissible and liable to be expunged from the records. Petitioners in response argued in paragraph 4.1 and paragraph 6.0 to 6.2, paragraph 2.123 of their response to second respondent, and paragraph 2.16 to 2.7 of their response to third respondent, that they actually paid certification fees to first respondent for their said documents, and that there were issued receipts by the first respondent. Some of those receipts, they said, were attached to the documents themselves, while others were separately receipted for, including, in one instance, payment of 6,669,301 naira 25 kobo, and another for 150,967 naira 50 kobo. They argued that it was therefore unconscionable of first respondent who collected such huge sums of money from them to turn around and plead non-payment of certification fees. Then Senior Counsel on petitioners' behalf also pleaded the Evidence Act's presumption of regularity of official acts and submitted that it was strange that a public institution like first respondent will come before a court of law to disown documents officially issued by it. In specific response to third respondent's argument, counsel to petitioners argued that Section 104(1) and 2 of the Evidence Act 2011 does not prescribe that the amount paid for certification must be reflected on the certified true copy of the document as part of the certification. So the argument of third respondent's counsel that because the certification of the said exhibits did not carry the amount paid for certification, certification fees were not paid for is clearly erroneous. Now, Section 104 of the Evidence Act provides every public officer having custody of public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it, as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document. As required by subsection 2, payment of certification fees is only a condition precedent to the certification. So it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama. And see also Uzoma and Sodike, ANPP and PDP, all these were made clear there, where it was held that certification in fee contained in separate document is sufficient. In this case, not only is there evidence of certification fee payment by petitioners first in the form of SBPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and attached to Exhibit PAF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made via receipt number RRR 270-842-653235 and on INEX receipt number 069727 of 25th of May 2023. It specifically states on its face thus: the sum of 6,696,301 naira 25 kobo only, being payment for CTC IPO electronic of a copy of data level number, data level, although not very legible, with time, then stamp, event history, polling units of EC8As and S yet to be uploaded from EC9 and other documents 2023 presidential election unquote. All that, in my opinion, is sufficient evidence of certification fee payment. Even more so, when the receipt indicates that the said payment also covers other documents outside those specifically mentioned therein. The burden had thus shifted to the first respondent, INEC, to show that the monies it received from petitioners for certification fee payment did not cover the documents they are now talking about, which documents INEC interestingly also certified. That burden INEC never discharged, especially when account is taken of the fact that it did not even give the amount assessed, if any, that petitioners were owing them for certification. By the provisions of Section 104.1 of the Evidence Act, an applicant for certification of public document is only obliged to pay what is assessed by the public officer. What is more, the mere fact that respondents certified the said documents for petitioners, coupled with the evidence of certification fee payment by petitioners in Exhibits PD and PAF 4C, sufficiently triggers the provisions of Section 168.1 of the Evidence Act 2011 that says when any judicial act or official act is shown to have been done in a matter substantially regular, it is presumed that formal requisites for its validity were complied with. This ground of the objection is therefore overruled. Then on the issue of alleged engravement of certification, it was also argued by the respondents relying on Belguri and Ahmed that certification of the same documents was done by a public officer of INEC by engravement of his name, official title, and date instead of subscription, so that also, he said, is invalidated the documents and rendered them inadmissible. I've carefully perused the said documents and verified that that, unlike Beguri and Ahmed, the documents in issue here bear the long-hand signature of the relevant certifying public officer of INEC. That, in our opinion, is substantial compliance with Section 104 of the Evidence Act and attracts the presumption of genuineness via Section 146 of the Evidence Act. First and second respondents in particular also argue that exhibits PAH1, PAH2, PAH3, and PAH4 tendered by PW21 Mr. Samuel Odunta and exhibit PAR8 to F tendered by PW26 Mr. If it is satisfied that the order required is for the purpose of instituting, maintaining, or defending an election, unquote, this does not in any way give petitioners the leeway to adduce evidence in breach of Section 83, sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of instituting or maintaining an election petition. Nothing in that provision allows a petitioner to file evidence, let alone the bulky expert reports as in exhibits PAH1 to 4, PAH1AF, PAR1A to F during the pendency of the petition. The whole idea behind Section 83.3 of the Evidence Act 2011 is to eliminate the danger inherent in allowing a party to manufacture and bring in evidence specifically tailored in anticipation of a case, or was to produce such fresh evidence after the case had begun and parties had fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH1 to 4 and PAR1 A to F, prepared and filed by experts long after pleadings in the petition had closed, when respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them in the said reports. I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as exhibits PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, C, D, and E, and F are without prejudice to our earlier decision that the incompetent is also rendered inadmissible in evidence by virtue of Section 83, sub 3 of the Evidence Act 2022. Oh, sorry. Evidence Act 2011. Then the next one is inadmissibility of election documents tendered as exhibits by petitioners on grounds of absence of pleading to support them and consequential irrelevance to the petition. The respondents' argument here are given. So we'll now skip that to the resolution. We've seen that, and the resolution we have is, it appears clear to me that the respondent's objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and his agents wrongly and deliberately entered wrong score.